দাঁড়া এটা আসেনি কেন আগে এটাকে করুন ফিক্স করুন yes what are you mentioning today
Well, I would not have troubled your lordship otherwise. Well, we are aware that your lordship is traveling to Jalpaiguri bench. Well, that is one of the other reasons why we can't wait any further. I'll tell your lordship, my lord, proceeding under the Public Premises Act. Well, there was a stay when I filed an appeal before the district judge. Stay continued. Well, before the district judge, it has been my appeal has been dismissed. So, my lord, I am facing the threat of being dispossessed.
when you file
by
the revision
But revision was filed on the 18th. It is appearing in the list as item number 252. They are on caveat. I am mentioning upon notice. KOPT is the public authority opposite party.
এটাকে at one
Deeply obliged, my lord. I will give them one more notice.
but if they are not there
No, I will give them one more notice.
no if they are not there
I can
cannot
understand, my
I'll
lord. I
not
can
be in a
understand.
position to pass because after all then you should have mentioned yesterday I would have upgraded it
Yes, I can appreciate, my lord. One of them. একটা বললে, একটার সময় বলছে।
it is in the list
Yes, it's in the list, item 252.
But my file was put for declaration of his tenancy right against my predecessor in title.
55,
2001.
252,
2001.
252.
My predecessor in title, my lord, filed legal statement along with counter claim for eviction of the plaintiff. I took out I am the subsequent participant from the original landlord. I took out an application for acceptance of the said counter claim.
Sure.
But that has been rejected by the learned trial judge. A suit is of 2001, we are in 2020, but I am suffering, my lord. Very abstract proposition law.
okay, I cannot pick up your matter
Well, find it text it up anything in the December, and it is a supplementary list, anything.
was it list not in the supplement I not my practice to fix its matters in supplementary list and this is not the mentioning day you hand
But anytime, in the second week of December, the matter is pending to the learned trial court.
it will appear in the monthly list sir yeah
My lord,
it is there in the monthly list
It was just filed by application.
right here a monthly list is there
Any table can give me a specific.
it will be appearing in the list thereafter you mention how can I do it I do not allow any matters to be my practice is you know sir after the matter is heard I give priority to those matters after the matter is heard yes will it appear then yes sir
Item 202. There is no private party, only state.
no I will not do that
My prayer would be, I will be praying for lordship only direction so that I can submit upon the government Peter.
not like this sir it is not like this matter has to come up there
Yes, it's appearing to lordship.
no not on mentioning sir matter has to be called on
Fifth is the day.
what can be done sir yes
my lord.
bear with me sir I'll be yes sir yes
Lordship, I'm praying for leave to file this revision application without the certificate.
what is the urgency
Urgency is that the bank is proceeding against my property. I have
when
obtained
the order was passed
Lordship, order was passed on 19th August. Order was
August. Sorry, sir.
Lordship,
No
Lordship,
urgency. Yes.
Today I know
File it
the
with
in the
the certified
DRT, but
copy.
DRT, the stay was vacated.
File it with the certified copy.
Lordship, kindly that the bank has already
19th
threatened.
August. Are
No, Lordship, that is the DRT order. That is the DRT
DRT
order.
order vacated.
DRT অর্ডারটা বলো কবে সেটা তো
DRT,
DRT
DRT order is 23rd
October.
23rd September. September.
Yes.
To kindly appreciate that they have
No,
threatened
sir,
us.
you file with no leave for that. You file it, it will appear. All matters will appear. File it
I
hand
mean,
over.
it's not accepting without the leave of this because
Why will I grant a leave? To obtain the certified copy. In October, the order has been passed.
yes, Lordship, I tender apology for that because
You
it is
when did
our-
you apply for the certified copy?
apply just day before yesterday.
Sorry, sir.
Lordship.
No. Certainly not. Yes.
extension of interim order expiring today.
What can be done? Expiring today. You cannot list it. I cannot list it today. You also have to have come earlier.
I ought to have, my lord, I'm enjoying a stay against an order of the district magistrate, my lord. It's an appeal from a DRAT order.
Apply before the other court.
But today it will expire.
What can today if you come nothing, it cannot be listed
Lordship,
today.
kindly.
It cannot be listed today without notice to the other side. Is it possible?
I'll give notice.
How will you give notice? Why have you come today? Sorry, sir. Not this way, sir. Cannot be possible, sir. I cannot. This will become an oral order. I will not pass an oral order like this. Matter is in the list. No, no. No, yes, sorry. Sir.
May be listed.
No, Monday.
Your lordship will not be there. Otherwise, I would have.
Unless the matter is in the list, you can't get it heard before the other court. Extension of interim order on Monday before this court, so that you can try your luck there. দিয়ে দাও extension of interim order. Wait, দাঁড়ান পরে I'm mentioning শেষ হোক। Yes, what do you want? Yes. পরের সপ্তাহে it will appear. Assignment today, I am not too sure. Tomorrow, you see, circuit is from next week. So, whatever.
Available date.
Yes, it will appear on the next available date. Yes,
My lord, I am late by Mr. Thakkar. He is online.
yes.
There is an urgent matter yesterday, my lord. The Honorable DRT has passed an order, my lord. He is there online.
I want to leave, Mr. Thakkar.
My lord, 10:30 p.m. last night, my lords, we received an order refusing stay of the magistrate's order, my lord. Now the DRAT is not in session, my lord, and they will not be here for some time. And my lord, the DRT has earlier passed an order staying this auction. Auction has been stayed, but now I will be dispossessed on Monday, my lord.
Very well. I'll grant leave, file,
Fine.
Monday listed.
Grateful, my lord. Grateful, my lord. Deeply obliged.
Move the, Mr. Thakkar, but you have to move the other court. You remember it will be listed on Monday, move the other court.
Your lordships is not.
I'll grant you leave, listed.
Please.
Monday, so that you can show that.
Grateful, my lord.
Yes, have you obtained a server copy? Without the server
Yes, my lord, I have a server copy. It was uploaded last night. Kindly grant me leave to file without certified copy.
without certified copy, ঠিক আছে দেবে। আর if she can bring the number, তাহলে সোমবার urgent motion হিসেবে list করে দেবে।
Grateful, my lord, deeply obliged.
Number, Mr. Thakkar.
Yes, my lord, with the number. It will be filed today, my lord. Has to be.
It cannot be. If you don't file, then it will not be listed.
No, my lord. I'll get the number and I'll give it to your lordship's officer, my lord.
Yes, then you can try your luck before the other court.
Grateful, my lord. Grateful, my lord. Deeply obliged.
পিছনে লিখে দিন না। Grateful. your lordship.
Urgent motion হিসেবে লিখে দেবে তলায়।
From the list, item number 1.
Lord, item number 1, 2, and 3.
এই আজকে
Lord, I to appear for
আজকের এগুলো কি হলো?
was disposed.
Dimensionটা কি হলো? So what is happening? কোথায় দেখি?
Lord, item number
Yes. Mr. Banerjee, I
Lord,
feel
item number 1, 2,
Yes.
and 3 was disposed.
yes.
Yes, my lord. Manager was leading.
The appeal is pending. How can the suit be disposed of?
Millard will withdraw the appeal. Millard will withdraw the appeal. Millard will file an application. And
Yes.
Millard will withdraw the appeal. Millard will get it heard before the learned trial court. My lord can Millard record our undertaking to that effect.
Come back. Mr. Banerjee, you withdraw the. How can I direct this?
Millard, on our undertaking, if
I'll direct the suit to be disposed of. Please understand, Mr. Banerjee. You
Millard,
are-
I follow. Millard, I follow. That's why Millard, our submission before your lordship was that Millard.
As far as I remember, the appeal was disposed of.
No. Millard, the appeal is from Millard ex parte identity order and Millard for subsequent extensions, which is pending. Millard, our submission was that Millard, nothing is being touched, not the appeal, nor Millard, the injunction application, nor Millard, the vacating application.
Mr. Banerjee, I'll
Yes,
place
Millard.
under the heading to be mentioned on the reopening date. Means
Millard, very well. Millard, I leave it to your lordship. Millard, may I just make one Millard short submission? Millard,
Yes.
pendency of an appeal,
same order.
Millard should not be an impediment for the Millard trial court to hear out the injunction application.
Mr. Banerjee, you have worked before the trial court. The records are called for. You know how the system works. Unlike the high, the entire records are called for. Once the record goes there, what will the trial court have in his hand?
Millard, when Millard is troubling your lordship, Millard will give an undertaking, Millard, on the next day.
No, I'm not saying so. I'm just placing this matter on next. I'm recalling this order, placing as to be mentioned. I'll pass the same order. You just show me.
Very well. We'll do that. Will do.
See, although an order for expeditious disposal was passed, expeditious disposal of the above suit was passed on 13th, 13th passed on 21st of November 2024. However, while correcting the unsigned order, since it appears that the appeal itself is pending, appeal from an interlocutory order is pending, let the above order be recalled. Full stop. List this matter for further. List this matter. At this stage, Mr. Banerjee, learned advocate representing the petitioners, would submit that steps have already been taken. Have you already
No,
taken?
but it has not been taken, my lord, we shall take this.
Would submit that they will proceed to withdraw the appeal. They are not
My
interested.
learned advocate on record is there, my lord, we are making this submission on instruction.
No, naturally. Then no, I'm
Yes.
not. I'm not saying if you want to make that submission, then only you make the submission.
Kindly do not record this today, my lord, let us come back, my lord, to your lordship when the matter will be taken up as to be mentioned matter.
Let this matter stand. In view thereof, let the unsigned order dated 21st or 20th November 2024 stand recalled. Full stop. List this matter for further consideration under the same heading on বলে ওই একটা supplementary list এ মঙ্গলবার দিয়ে দাও Tuesday তো তিনটেই একই order.
My lord, this Tuesday, my lord is keeping the matter.
Same I'm heading. You come up with it.
No, my lord, this Tuesday, my lord will not be possibly there, my lord, I am told my lord will be there in the circuit bench.
That is on 9th, 10th.
Oh. So
Then-
grateful, dear. Yes.
So you have enough time.
Yes. My lord, we can also take care of the appeal then, my lord, in the meantime.
Yes, get rid of the appeal, whatever. Without the
Absolutely.
before a trial court, ordinarily what happens is the entire lower court's records are called for. Once the lower court records are called for, what will the trial court
That's how, my lord, interim orders are secured for eternity. This is what happens.
do the system? But you can't
True.
say because it is not possible because all
Very
the
well, my lord, we have followed, my lord, the trouble that my lord is facing, my lord will come back, my lord, to ease the matter.
yes.
So grateful to your lordship, my lord, grateful.
Yes, 10th of December. If you can withdraw, then I will pass appropriate orders on that.
Yes.
ঠিক আছে
Item number 4, ma'am.
ওই যে ওইখানে আছে অর্ডার গুলো রিকর্ড অর্ডারটা আলাদা ছেড়ে দাও Yes.
Yes, my lord. In this matter, I am appearing on behalf of the petition, my lord. The fact is that it is a gratuity claim, my lord. Petitioner retired in the year 2012, my lord. He's working in JShop, filed application before the controlling authority. Thereafter, certificate were issued. After that, my lord,
Yes, who is appearing?
Mr. Somnath.
What is your prayer in this application?
my lord, certificate authority already received notice certificate, and he is just the matter is pending before the certificate authority for long.
Mr. Somnath, I'm led by Mr. Somnath Ganguly. Somnath Ganguly is engaged lordship another court.
Very well. The present application
Grateful.
I am obliged.
But in despite service, none appears on behalf of the respondent number. Private respondent is
Respondent number 5.
respondent number. Sir. Service is there. You have seen.
Yes, my lord.
Have you checked up? Service complete.
Yes, yes, yes.
Okay, ফেরত দাও, ফেরত দাও.
I have the copy.
Yes, madam. Service is complete. On respondent number 5.
My lord, the respondent number 5, that is page 12 of this service, my lord, that is item returned address left without instruction.
Very well. The affidavit of service filed in court is taken on record. করে ওই তুমি ছেড়ে দাও, আর কই despite service করার দরকার নেই. Yes, madam, it is for you. Respondent number 5 is not, they have nothing to say. Certificate has been already issued by the controller. So that decision is over. Any appeal preferred? Any appeal preferred?
My lord, I have no instruction of any appeal.
Very well. Yeah, that one. What, next?
I am obliged, my lord.
My lord, I am for the, this is for extension of interim order. Yesterday, only the application was not there. That is substitution application. Petitioner expired in the meantime. So I made out a substitution application also.
And where is the service of the substitute?
My lord, this service could not be affected because, my lord, I have actually, my family had some problem in
Sir,
hospital.
that is all right, sir. I am
Last 2 weeks I could not do it.
servant come.
My lord, interim order is going.
That is gone. Only petitioner.
Yes. Only petition, yes.
Sir,
I am for OP 1 to 7.
My lord,
would be knowing, sir,
my lord.
without the service, the order.
Yes, yes, and actually I have served after the revisional application.
Unless a substitution is there, no interim order can be passed on this
Yes,
application,
yes.
sir.
My lord, only the difficulty is actually
Which application
can one, my lord.
can 1 of 2024, full stop. Can 1 of 2024, full stop. The instant application has been filed, inter alia praying for a recording of the death of the sole petitioner and for substitution of the legal heirs
My lord.
of the petitioner which paragraph which paragraph
My lord. Paragraph 5. 5 and
sir, what are you saying?
Paragraph 4,
Substitution,
paragraph-
sir.
paragraph 4.
Sir, what is your case? Substitution. Have you read the order? Read the paragraph?
No, no, this is not the paragraph.
No. Kindly read place the paragraph, sir.
Paragraph 4, during the pendency of the present revisional application, petitioner plaintiff expired on 17th of July 20, leaving behind 5 sons and 2 daughters. my lord.
Very well. Next paragraph.
Yes, my lord. That is.
So what is this application? Assignment.
No, no, no. My lord, actually, the only
Take
those-
instructions. Come back.
my lord.
Check up. কোনো order দিও না। List in monthly list. ওকে দিয়ে দাও। কিছু হবে monthly list এ ঢুকিয়ে দাও। Same position. It will appear.
My lord.
You take steps.
Great.
If you have to correct that, come
Yes.
up with supplementary affidavit
My lord, my lord.
on or I do not know what you.
My lord, my
It is for you to take steps.
Grateful, my lord.
No. Yes. রাখুন।
Other services বলে দেন
By the, my lord, at that point of time, my lord has the determination, my lord. As my lord was issued rule, my lord, that's why.
I asked him, whether this court passed the order, he said yes.
The rule was issued by my lord, my lord.
Sir, was issued by this court, please, I'll give you the correct submissions.
Sorry.
Rule was issued by another court, and because this is what he got,
Yes, my lord.
I restored it and directed the contenders to appear. What did you come and say? Content application has not been there. I asked whether this court passed the order. You said yes. I rely on my advocate, sir. You are my officer.
This one,
You
I
have to take responsibility for whatever you say.
am not in this matter, my lord. But I am not in this matter, my lord. Sorry. Yes, yes, my lord. I will inform.
Rely on my officer. You are my officer. I rely on your statements which you made in court.
Good.
এক্সটেনশন করে ডেট ফিক্স করতে হবে
I will stop moving confidence that I and this will not be good for ultimately suffer some difficult. No, I was going to take someone else to task. And I was very serious because you see what happens if such things occur. People will lose confidence in the court. Despite direction, matter is not appearing in the list. Although he has no fault. I was relying on your statements made in court. Without checking up the same, you made submissions in court. And you can get out with this.
I will inform.
Almost 6.
Once.
whether another project having jurisdiction you should take up those
Naturally, I asked it, sir, I found it. Yes.
as your lordship recall that order that's now the executive court is there for hearing of the
This matter.
extension. That kindly Millard extend and fixes that date will have that. Yesterday, none. So what the proper opportunity to after 12 days. 12 days will
January month. January month. Almost 7.
Good.
My lord, I beg to appear on the petition. My lord, this is extension of order, my lord. Passed by our honorable coordinate bench on 31st July 2024. Yes, ma'am. Yes, ma'am. No, to serve the landed advocate as well as opposite party or. Ma'am.
Number 9.
For the responding.
I am appearing for the plaintiff petitioner for vacating of the interim order.
Application vacating the interim order. Past expert.
And there is a direction that you have to file the certified copy of the trial court judgment, my lord, because the photocopy was there. No, earlier order dated leave was granted to produce the same at the time of hearing. So the order dated by the 8th August, my lord, will find. Yes, that is the. Yes. Yes. Well, no, you could just
Yes, but, this order, I'll tell your lordship the story in short. In 2000 yes.
I want to file opposition to this application.
He can, because he's got it ex parte. Now, in 2010, my mother gives me I've served it on him. 12/9/2024.
Before Justice Basu, upon notice, my lord, I have mentioned it. Thereafter, my lord,
Yes, your lordship. I can understand. I can understand. Yes, because this has to be heard out. Because I'm suffering a little bit more after 13 years.
If just
This is something put on the knife. Whether knife comes on the... Yes, yes, yes. Not that. It is. Yes, yes, yes. If there is no appearance of the petitioner, interim order cannot be extended. Yes, he is suffering. He is. At least the petitioner should not ask for adjournment in 3 ground. No, that is what. That is what I am submitting. Yes, yes. Well, of the trial court. Order dated 10th May 2023. Passed by learned Civil Judge Junior Division 2nd Court, Paschim Midnapur. In title suit number 2.
The interim order is. The interim order is extended till minutes. Next, no.
Probably goes on to January or February, because that's what I was saying.
Only up to December, your worship, till the next day. Till the next day. I'm deep. Yes, deeply.
Application happening.
What happens? No. Okay. I'm deeply.
Well, Mr.
Lordship, I beg to appear
Now
for the
the next matter,
party
Lord, I beg to
respondents,
appear
my
for the
lord.
petitioner in this. The last this matter was
Lordship,
taken up for hearing. Lord, they have filed an
my lord,
application for vacating of the interim order.
The Lordship, yesterday, as your Lordship said, my lord, we shall not go into the merits of the application, has been preferred by the petitioners, my lord. I am not taking your Lordship into the merits, my lord. I am only seeking a very short direction, if I may. Even my learned friend is also there. Is my lord will kindly see the impugned order number 100, which they have challenged, my lord, in the application. My lord, can you hear me, my lord? Am I audible? You are audible. You are audible.
My lord, will kindly see the impugned order, my lord. What has happened was there were multiple proceedings simultaneously in the learned trial court, my lord. And in that, there was also an application which was being heard out under section 340 of the Criminal Procedure Code. Now, my lord, that application's hearing was completed and there was an order for submission of written notes of argument. Now, my lord, then the records got misplaced, and therefore what happened, my lord, even though separate orders, my lord.
An application under Order 7, Rule 11.
No, my lord, this is what I'm saying. They have challenged an application under section 151 by which we had sought for compliance of certain directions issued by the learned administrator which were not being complied by the plaintiffs. The petitioners came up with a point that during pendency of Order 7 Rule 11 application, this application cannot be heard because this touches the root causes of the suit or not. That is the merit of their application before your lordship. I'm not going into that. The lordship will kindly take up the impugned order, my lord, at the end of their application, my lord. It will explain, my lord, what I'm trying to submit. The lordship will find at the bottom of the impugned order, your lordship, there is an entry called later. Your lordship has found. My lord, what has happened was there was a simultaneous proceeding continuing in the learned trial court under section 340 of the Criminal Procedure Code, in which the hearings were completed, written notes were scheduled to be submitted, then the record went missing. Now, my lord, what happened by the order on 27th of August, my lord, by this honorable court, which directed that all further proceedings before the learned trial court to be stayed, my lord, this 340 also became effectively stayed. My lord, at this juncture, my lord, I am only praying for a short clarification that the trial court may proceed with the application under section 340 of the CRPC, which is not before your lordship under any challenge. They have not challenged their proceedings, not the order, nothing. That's a simultaneous proceeding. continuing before the learned trial court. The rest I am not touching, my lord. As I have given my word, my lord, I will not go into the merits of their present civil revisional application.
But 340 is a separate proceeding, so my lord, I don't
Because they
object to
challenge,
this,
because they challenge,
prayer.
because they challenge this particular order 100 and it
340 is a
was
separate
tagged.
proceeding.
My lord, kindly allow us to proceed with the section 340 with the learned trial court. That is my limited submission. That is all. I don't think my learned
Yes.
friend will have any objection to that, my lord.
I don't stand in the way. I don't stand in the way. Because suit does not have anything to do with 340. 340 will have its independent course.
My lord, I am
I don't
grateful
stand
for
in
his
the
fair submission, my lord. I am grateful. That is the only short submission, my lord, I want to make at this juncture.
Extension of interim order. Mr. Kormukar, learned advocate appearing in support of the aforesaid application, would submit that the interim order is due to expire at the end of November 2024. As such, he seeks extension thereof. Mr. Chottoraj, learned advocate appearing on behalf of the opposite parties, would submit that he has already filed a vacating
My
application
lord.
and his vacating application should be taken up for consideration. He has already filed a vacating application, full stop. By drawing attention, full stop. By drawing attention of this court to the order impugned, he would submit that independent of the issue raised in the revisional application, a proceedings under section 340 was also taken up for consideration.
My lord, 340 under criminal procedure code, my lord, if your lordship will kindly.
Under section 340 of the Code of Criminal Procedure was taken up by the learned court. However, by reasons of the aforesaid order, by reasons of the order dated 27th August 2024 passed by the coordinate bench of this court, the said application proceedings in connection with the application under section 340 of the Code of Criminal Procedure has effectively been stayed.
My lord,
Is not proceeding with the same. Full stop. Mr. Kormukar, learned advocate, submits that the order impugned, or he submits that the challenge in the revisional application is confined to the
An application under section 151 of the CPC, my lord.
confined to the order whereby confined to expeditious disposal of the application under section 151 of the Code of Civil Procedure by retaining the application under order 711 pending. Yes.
Yes, sir. Lordship.
Mr.
Lord, my challenge is a bit different. Lord, am I
Yes, you are audible. Yes.
able to your lordship?
Yes.
Lord, my challenge is that disposing of order 711, no other application be touched in a suit. 340 is a separate
So that is what I record.
miss case. So I said that yes.
That the challenge in the revisional application is confined to the explicit application under section 151 of the Code of Civil Procedure by retaining the application under order 7 rule 11 pending.
By keeping the order 7 rule 11 pending. Expedition of disposal of the application. Having regard thereto, and having heard the learned advocates appearing for the respective parties, and having considered the materials on record, it is hereby clarified that the aforesaid interim order is restricted to the continuation of further hearing.
My lord, will see the order on 27/8/2024, my lord, of this court. The first part of the order clarifies.
51 of the Code of Civil Procedure.
My lord.
Without having the application under order 7 rule 11 of the Code of Civil Procedure being disposed of.
My lord. That is what is their challenge.
Yes, Mr. Kormukar, it is all right.
Lord, my yes. Lord, my interim order stay of the all further proceeding of the suit. My lord, interim order was only stay of all further proceeding.
Then 340 also comes.
Yes, my lord, that is the issue. That is the issue.
340 also comes in.
340 is a proceeding.
No, my
It
lord,
is
my lord, my friend is not
Lord,
actually
340
submitting correctly, my
separate
lord.
proceeding comes under a mistake.
No. This has been already clarified by an order, my lord. If your lordship,
Proceedings in connection with the suit only.
with the suit.
Yes. It is not an independent proceedings.
It's not an independent proceedings, my lord. And that was also clarified by an order of the learned trial court, my lord.
Mr. Kormukar, I have clarified the position that without disposal of Order 7, Rule 11, the 151 application cannot be taken up.
My lord. That is what they're asking for.
Mr. Chattaraj, let me dispose it of today itself by permitting the court to, if you agree, by permitting the court to dispose of Order 7, Rule 11 first.
My lord, your lordship will find that it has got no connection. This is a compliance about the administrator's directions passed, which was not being complied by the plaintiff. The administrator, my lord, my humble submission before your lordship, subject to correction, my lord. The administrator is a custodial legislator. My lord, my learned friend will kindly allow me to complete my submission.
Please understand. Do you say that the Order 7, Rule 11 application should not be taken up by the learned judge?
No, my lord, this is what is the issue. That is why I'm not going into the merits, because your lordship is in dearth of time. My lord, your lordship is in dearth of time. Because of that, I am not going into the merits. This 340 has come out of the Order 7, Rule 11 application. Being now, your lordship am I audible, my lord?
Further hearing of any other proceedings in the suit, though is restricted. Though the interim order pertains to further hearing of any other proceedings in the suit, the same shall not the same shall not stand as an impediment in.
So this will create a problem again. So
Now
this
see,
will
your lordship,
create a problem
this is the
because
problem.
there are other applications pending. Lord, again the same thing will happen. I say
You
that
have not
without
challenged the other
disputing
application, my lord.
No, only 340 will. Wait.
Only 340. I am only praying for the 340 to proceed, my lord. That's all.
Yes, kindly clarifies that. Kindly clarifies to that extent. Nothing more than that. Because other applications are also pending. I say,
listen.
Without hearing Order 7, Rule 11, no other orders can be passed.
My lord, he has not challenged that.
Both
Today he is asking.
Argue, then come to court. I cannot hear you like this. Please
Yes,
hear.
my lord, this is the issue why I was not pressing it. This is the only issue why I was not going into pressing all the other grounds.
Hear the order, Mr. Chattaraj.
My lord. There is some problem in the network, your lordship. That's why we are getting.
Mr. Komokar submits that the challenge in the revisional application is confined to the disposal of the application under section 151 of the CPC.
No, disposal of any other application is confined. No, is confined. Is confined to confined. No. Would submit the challenge in the revisional application is directed against proceeding with any other by proceeding with other applications by keeping the application under Order 7, Rule 11 pending.
My lord, this has not been challenged. That is my humble submission.
Yes, challenged.
No, my lord, that is kindly seize the application.
Order passed by my predecessor records this.
My lord, kindly, this is exactly is what I was submitting, my lord. This is what has been recorded. Kindly
in
the
that
order
case,
passed by Justice Basu.
Extend the interim order.
Kindly seize the order passed by Justice Vishwajit Basu, my lord. Kindly seize the first part of the order. Your lordship will get the details what they are challenged.
If you want to argue, Mr. Chattaraj, come to court.
Yes, I am not arguing, my lord. Kindly, my lord. I am not arguing. But he has not challenged that all other applications should be kept pending.
That
Hereby clarified.
that though the interim order pertains to any other proceeding in the suit, the same shall not stand as an impediment in having the application under section 340 of the CRPC heard out.
Yes.
My
The
lord,
order heard out. The interim order passed. The interim order passed on 27th August 2024. Stands extended with the above variation.
my
Stands
lord, I am grateful, my lord.
end of April 2024 with the above variation. Your application I am disposing of.
Which application, my lord?
Picketing.
My lord, they let them give an affidavit, my lord. We have got serious grounds. We have severe grounds, my lord. That has to be heard out on merits. It has to be heard out on merits, my lord. That is my humble submission. The vacating application.
If the revision application is heard out once and for all, I don't think any other objection will be required. My lord fixes up any day not for the revision application, we shall come back and argue the revision once and for all.
My lord, let them file affidavits against our vacating application if your lordship wants, my lord. I have no objection to
It's
that.
a revision application, no factual aspect can be gone into. This is only on a point of law, nothing more than that.
Grateful, my lord.
Grateful, your lord.
Great.
Well, I am for
Guardian and WhatsApp, but there was a direction for visitation of the minor child of 7 years, but in the premises of the mother.
Petitioner.
I am for the petition. Mother.
The interim order is there. Any vacating application filed? Mr. Vasu, I will extend.
A limited period, man. What I
That is different, but don't argue without filing vacating application. Hey, Mr. What are you doing, Mr. Vasu? The matter has come up under the heading extension of interim order.
This is my lordship. I have mentioned this matter for extension of interim order, lordship. This is the affidavit of service. Though on the last occasion, learned advocates appeared, but today they are not appearing. I have given them notice of mentioning, lordship, for extension. My interim order is till the end of November, lordship.
This matter has come up under the heading extension of interim
Yes,
order.
lordship. Yes.
Item number 13.
Well, I am for the petition. My lord, the petitioner before your lordship is the cooperative bank. My lord, he is contesting in a suit. My lord, filed by the opposite party number 1 hearing. My lord, an application under order 6.
What is this? 13 motion?
Motion, my lord. My lord, tomorrow is the date fixed for my lord DW. That's why the matter was mentioned, my lord, before your lordship. And your lordship has been pleased to fix this matter today, my lord. My lord, on behalf of the bank, my lord, an application under order 6, rule 17 has been filed. That was turned down by the learned court below, my lord, challenging this order, my lord. We have preferred this instant revision application.
Oh, yes. What
My
is
lord,
this?
only, my lord, limited purpose, this application was filed under order 6, rule 7, an amount which has been mentioned in the WS, my lord. It is 2,53,000. Inadvertently, it has been mentioned 2,53,000, but it will be 2,45,000, my lord. Only to that extent, my lord. My lord, if your lordship kindly takes me into the page, my lord, 38, that is the WS, paragraph 20, my lord, last, my lord, paragraph, page 38, last paragraph.
Only 38.
Page 38, 380.
No, there are other.
No, my lord.
So you are now
Only for incorporation, instead of 2,53,000, it will be 2,44,000.
only for this purpose.
Only for this purpose, my lord. And my lord, what?
The present divisional application has been filed, inter alia challenging I gave you that opportunity.
Although the order passed by does not although apparent or stand of the opposite party. Yet, the above but it matter as an example grateful
Do.
I don't also know, that's why you give me the indication, you are not following.
সবটা বাকি রেখে দাও।
Order number 14.
I'll come back. No, no, I'll come in 5 minutes. Just I'll come in 5 minutes. No, no. It's maybe 12:30.
But once you get
I know. বন্ধ করলেই তো হয়, বন্ধ করা যায় না, এটা বন্ধ করা যায় না টোটালি।
Why is the bar lordship has stopped?
Then it is good. Then good. Then go work whatever
That you'll get to know in a few days. It's not still not public.
And anything suppressed in High Court.
Yes.
That's it.
Nothing is suppressed in the High Court. Yes, yes.
Yes. And our touch point.
The main issue was resolved by so you are placing the order in queue.
I don't know. That is BP is with my lord. If the both the court's certified copy is with my lord, otherwise it is defective.
No, that I granted leave. Before it is final.
I can't follow. What? Yes. What is the style for sort? Rules provide that you have to file both the certified copy. My lord granted leave so far as the appellate court order is concerned. This is appellate. What is trial court order? No. They cannot. It is not maintainable then on the rule. No, the difficulty is my lord. Nowadays, the lordship is not adhering to the rules. Maybe amend the rule. My lord's full court can amend the rule. If no, had it been Justice Visitation Basu, no difficulty is juniors could not learn. Justice Basu will not allow it in any cost. And my lord is giving. I am not blaming my lord. What I am saying, what the junior will learn, which one is correct? Certainly. Oh no, that is a but I have taken something else. No, you know best point.
The reason for rejecting it is that they page 14, you have to kindly see arguments that are pretty ignored. They kindly see my written notes of argument apropos this at A or main conditions of the brochure as not been. But I will just show the brochure scales for or beloved. Now, what is the finding of the learned judge? The learned judge finding is not that we are resolving the case because that possibly not safe because subsequent to the finding out. So when which court if they presence the court, which court passed an order, giving me liberty to urge this point, and the court to decide. On that ground, my petition was dismissed. That is the order at the I accept. The Superior Court, yes, the report of the granted leave, possibility to apply the corporate savings. Kindly see anyway, as the question of law. These are all issues that we have to address. Question of grant of interim order. What is the scope pending? But I will not pending. I will hear it out. Yes, this is the interim. Finding of all those who can take a petrol pump. Nobody, all companies are bound to follow this guideline. our division bench judgment and any allotment contrary to the guideline is that. The reason made given in the order is that other part of the contract. Unilateral document, there's a question of being part of the contract. That's not the division bench judgment. Number two, it is not the court finding that this is beyond the suit or this is suit is my belief is that they should not be restrained from operating a construction and operating. Illegal, that is there. Now, why illegal? That has been brought on record by way of after the judge, this was brought on record, and because as I said, when we got the order, they came up in revisions of the order, and they took this point, and the revision for limited the interim order or the revision of the order. And not to that is the justice that is page 460. Page 460. That is volume 3. That's not the reason given, yes, but that yes. It is mentioned page 460. Also by the right? The subsequent event because we get the RTI response. Can you see? 460.
It may come back. It will take some time.
No. That's the event number 3. Remember? 1. Sure. With the order, I'm not sure because in this revisional application, where for the first time they disclose the letter of allotment. Letter of allotment, and thereafter we get the RTI response. What was the exact reason for making it construction? Because at that stage, it was the defendant's specific case that construction is going on. So operation will be next stage. Propose this guy says, not to run the pump it is secondary on the construction. Now, when it is
That's the whole point. Transaction started when we came, when we 24. That's when we get to know. That's when we get to know ostensibly. So we come to get, because they get allotment from the PCL or petroleum on 31st May 2024, which came to our notice from the revisional application. So we get an injunction in June. After seeing the construction starting, we get the injunction in June 2020. Now, my lord, when the matter is funded back, they file an affidavit stating that by June 24, we had completed 85%. So 50% was still, but it was much less. The BPC 15%. 15%. Yes, 15%. I will get an affidavit. Now, BPCL did not argue and say that I have already filled up their tank. In a complete construction, I filled up the tank. Yes, so that was not the case.
There was no injunction against her.
Yes, I'm guaranteed that.
We were allowed.
Not against them.
Our part is also part of the construction because we give it a final shape. The underground reservoir is put in. It is checked whether it's functioning, whether there is any leakage, whether there is any pollution hazard. Fire not upon us. It's specifically mentioned in the order. We are not resistant. They did not ask for it. Yes,
So
because it is.
Made clear that debate number 6 can do whatever they want. That is in the order which I just thought 760.
Justice Basu's order.
460 and 466. Yes, at 469. No, at 470. 470 seconds. This I will. The plaintiff is saying injunction 470 against defendant number 1 only. Therefore, the said order of injunction shall not deter the defendant number 6 to continue the infrastructure development application. Now, before the appeal court, I do not know. That's what is coming to. There is no affidavit from there.
The entire technical part. Entire technical part. To set up the petrol pump, they only
Facilitate, I suppose.
Lordship. We do it through our agency. They don't do it. We spend 80 lakhs for doing it. And they spend 1.2 crores. More than 2 crore has been sent. Yeah, I'm telling that. They construct the building. But there are a lot of other things. The entire underground part has to be done by us. The connections, setting up of the dispensing unit, the DU, then
Set up by you. Correct. The underground can be set up by you.
yes, because there could be pollution hazard and fire hazard also.
And thereafter, the construction was completed also by you.
Yes. Infrastructure. No, please. Entire. We have, my lord, I'm trying to, my lord, convey, my lord, the fact. We have.
Set up by you. Correct. That's it. So the tank also has to be set up by you. Correct.
Right. The administrative office, the adjoining store, and the road by which it goes to.
That these tanks are filled up.
And therefore, this should start. No, sir. You were aware of the fact that there is because I'm apropos what you said, that's what I'm saying. You were aware of the fact that there is a subsisting order of injunction. That for you proceeded, you have done it at your own peril. So that is a different issue altogether.
Road of entrance, the exit road has.
No, I was very loath to take it up any further because once you said that it was filled up with oil and everything. So that you have done it on your own peril.
The weight and measures department of the government has.
Very well. So that is neither here nor there. Your work you have completed.
I'll make my submissions when you.
Yeah, I will hear. No. Yesterday your submission, Mr. Mal, that's the reason why I.
My lord, I'll try to make.
It is all right, sir.
If.
No, it is. I initially that submission. Thereafter, I thought that the work has to be done by them. You have clarified the situation. No, naturally, it is your setup.
I'm sorry.
No. Why, Mister? I always seek clarification. That is the reason why I've sought for clarification from you. If I have any doubt in my mind, I'll seek for a clarification. There is no difficulty. And the matter is being heard. I did not pass any order.
Absolutely.
So therefore, you do the technical part, which internally include setting up the underground tank and the DU. And their work is the administrative building part.
Mainly, and the road to go in, road to go out from the pump, all those parts.
And after the tank is set up to close the entire place, concretization thereof, boundary wall thereof.
That is their part.
Yes, very well. I am getting good. Only clarification, sir.
Actually, it was the order.
Mr. Chattopadhyay, I'll come back to you. Yeah, I'll come back to you. Yes. It is complete. Where is that affidavit? Which paragraph? I.
Of the construction either by DPCL or by this one number one. And the refused order involved, record and pay. Internal page 15.
Yes.
Internal page 15 of the second paragraph on value the local advantage of unfinished now arguments are settled. Defenses has not put his case before the bound by the findings of the court and its operators.
Bound by that, yes.
They should not put their case that I have been so on my dad and I picked up the tag. Hardly 18th November was the order and it came on 19th November. 1 day later. The order comes 18th November. They should have got the office of that. So this being the position, yesterday to come and argue, and I have already I've installed the tank, I have built up the tank. That cannot be applicable to law. So the performance is that much bound by the findings that
The learned court has said you don't have a prime facie case.
yes. But because my work on this guideline, only you can get 40.
This was in a miscellaneous appeal.
But you kindly see. Okay, kindly come to page 7, 2, 7 to 7. This is from the division then. 7 to 1. This is the clause we're talking about. Clause 16 of our division. Let's go into the builder. Adoption of detail outlet marker. Quickly in terms of calculation.
kindly see, more importantly, what is the name of the event number one and what should see? Yes. Yes. What is the partnership? The lease is not in the name of the. What is the name of the partnership and what should be apropos this, the clause. Eight two five. This is the condition which we want to know afterwards. Once we came to know about all this, this is that guideline. Two five. And two five zero. This is the brochure. Where is the plaint? Plaint. Just a minute. Where is that before that? Where is the order refusing to grant injunction by the trial court? Which page?
Immediately before my lord, the order improved.
Oh.
No, 840.
So it says immediately before the order improved.
849, I believe, my lord, subject to correction, my lord.
Yeah, check it.
Volume 4.
It will be easier to find out there in one place. Oh, this is finally. Oh, so on the same ground also. No legal right. No legal right. That is no prima facie case. Very well said. MS
Taken note of by the trial.
paragraph first.
There in the.
What president? Which paragraph? Which paragraph? Paragraph? This is on the question of locus. Your only today, your only case is that since the interim order has continued so far, you should continue. This is your only case. Because today you see, two courts has held that you don't have a case. Privacy case and on contest. What then naturally, revision, no, I'm appeal, sir. What is the scope of a revisional court in hearing out such matter? Yes, yes. And this paragraph, page number 14, how was this issue answered? How was the issue answered? No, nothing. Yes, sir. Only I am considering the interim order question, nothing more than that. Because this hearing matter has to be heard out. There is something, I'm otherwise expressive, you are all aware. Mr. Chattopadhyay knows it very well. So, you see, this matter has to be heard out. There is some point which has been put forth by the plaintiff. Something.
Since 19th September.
May not succeed ultimately.
Since 19th September, when the interim injunction application was rejected by the trial court, there is no injunction. Since 19th September, for last 2 months.
I do not find it absolutely convincing. Now, entirely convincing, I would say, the case. But considering the fact, what if he were to succeed? Please understand. What if he were to succeed? What if? Then, in the interregnum, if the petrol pump, what is your stand? You got the permission? No.
Yes, I didn't have.
No. That is all right. Your part is okay.
Permission was granted by the DM, my lord, only after the permission.
Yesterday you said that you are yet to.
Permission was granted by the DM before the letter of intent was issued. That was continuing, my lord, after construction complete, my lord. After inspection done by the authorities, my lord. Selling license was, my lord,
is to be issued.
Yes, that was, I didn't have instruction. 20th November, it was granted.
It is not yet granted.
20th November it was granted. 20th November. I didn't
Or
have
the very
instruction.
next day.
I didn't have instruction. Number
Have you commenced operations?
No, not yet, my lord. Not yet. Not yet.
I will hear you.
No, my-
I'll hear out
No,
the matter, especially
no,
fixed.
2 minutes.
I will hear out because you are not a party. You are a party, but you have not. Nothing has been. No relief has been sought for against you to that
Yes.
extent.
So we have spent money.
Naturally,
How do they compensate? Ultimately, if they fail, we are losing lakhs of rupees every day. Are they securing that money?
so this were aware of the situation,
Kindly
sir.
take into care one thing. When was this advertisement floated?
Sir, you were aware of the entire situation, sir. The injunction order was continuing for so long.
Yes.
Mr. Mal,
We
you have
were
to understand.
nothing against me. They did not obtain any injunction.
Correct, correct. So I am not granting any objection so far as the injunction, so far as you are concerned. You do whatever you want. You had taken the order, you have considered there is an order. Let it remain. It does not bother me. It will not bother me.
Specific mention.
So
it does not-
therefore, once you say so, you cannot say when an order is passed against him, why are you concerned with his order? You said, I am not bothered with the order. I will carry out
we
the
have
construction
got
work.
monetary stake involved. We have spent money because of
What you have
specific
sought
order.
for appropriate protection at that stage.
Yes. Kindly see Justice Basu's order. It
Yes,
specifically mentions we are free to go ahead.
go ahead.
By go ahead, we are
Helping you.
invested capital.
So,
And my lord, who will take the risk of
someone
any
else
fire hazard and
expenses.
pollution hazard if it is not being run?
Oh, you had at your own peril, you had done that because you say,
After obtaining leave from court.
what granted you leave
Kindly see
to,
Justice Basu's
to
order.
fill up the tank.
Everything.
Where? Don't tell me all this, Mr. Mal.
Lordship will kindly consider one thing. When was the advertisement?
And nothing has
When
been
wa-
placed before this court as of today that the
Well,
tank
when
can
was
be
the
filled up.
advertisement floated?
Nothing
They
has
are
been
coming
placed
up
before this court.
now. Lordship will kindly see at this stage. Shobita dekhi?
Mr. Mal, let me hear
Lordship
it,
will kindly
Mr. Mal.
2 minutes, man.
I will have to hear the matter.
Lordship will
And
hear
this
it, man.
matter, this
Lordship
matter
will hear
cannot
it.
be completed today at the interim stage.
Lordship will kindly see.
Yes,
This
yes.
is public money. Lordship will kindly see. At this stage, they are seeking an order.
Where is that from the trial court records?
This is today.
Where is that from the trial court records? I cannot go and see that. Please understand. I have to hear, Mr. Vasu, this is the situation. The case made out by Mr. Mitro, I have seen both the orders. Both courts he did not succeed. In fact, before the first appellate court, it was said that he does not have a prima facie case also.
Both the court.
The first court said no legal right infringed. The issue of brochure was not considered by the first appellate court. Then a different issue altogether. He has to say, I did not consider because it is not there in the play. What are you saying today? What you are saying today? Let me hear me. And so therefore, this matter on this limited issue requires consideration. That is according to you, yes. That is
If
according
there is no pleading in the plaint, court is not bound to give any cognizance of
very
that.
well, very well. He may not succeed ultimately.
It's not question of succeed. He cannot ask the court to consider his case. Succeed is separate thing. I have a case made out in the plaint. I may succeed, I may not succeed. But if I don't made out a case in the plaint, and I ask the appellate court without amending the pleading.
I have to hear you on this.
This
No. Ari, naturally, I'll hear you. Will I not hear you?
both the courts below.
Mr. Vasu, you don't want the court to hear you.
Always don't.
So you are also aware that there are circumstances when the court has to hear the matter. And this is not that in 5 minutes this matter can be over. Let us be very candid and understand situation. So I will fix this matter on that returnable date when I come back at 2 p.m.
Why there will be injunction?
No, I'll not pass an injunction. Status quo as of today be maintained. Only, no injunction. No, not this.
Before
There is no injunction so far as Mr. Mal's client is concerned.
passing of the order, my lord, kindly once peruse this serious.
But I have to hear out.
Peruse.
So, then I have to decide this. If you are inviting the court to decide this today.
Minute time. Two
Yes,
courts
yes.
Admitted fact. Two courts concurrently.
I've seen that.
Okay?
Yes.
This judgment is on that.
Yeah, show me that. Yeah.
I'll come to paragraph 14. It was well settled now by a category of decision of this court that when the two courts concurrently rejected the application for injunction, it would not be open for the third court to interfere with the second concurrent finding until and unless it is brought to the notice of the third court that has findings are perverse. Is this perverse? I am asking the question to myself. Then can you stand over? Now kindly come to 27. Yes, 21. My learned friend had said. Therefore, in view of the concurrent findings of the court below, and also from the findings arrived by the advocate commissioner, he also advocate commissioner appointed. He said this is beyond highway. So Highways Act does not apply. The notification does not apply at all.
That is a main case. Commissioner will not decide that.
He said the distance, nothing else. On the basis of that, the lower appellate
Said
court,
that the work is not yet complete.
that I am not on that. I say commissioner said that it is beyond highway. If it is beyond highway, the highways notification does not apply at all. What is the case in the plain? That highways notification offending opening of a petrol pump within 300 meters. That is the case made out. Can we come to 27 then? If ultimately the rule filed by the applicant,
From which order this matter came up? From an interim order passed in a revisional application. Show me that. Where we
the original. Construction completed here. Here, Manoj, can you see photographs?
no, there was an injunction. How will the construction be complete? Correct. No. You have said that 15% is not complete. You have said so in your own affidavit, sir. The injunction continued. Mr.
Passport there was no.
I have to hear out. Mr. Mal, either you submit or Mr. Basu submit. Wait, Mr. Basu is submitting.
Disputing what I am saying.
Yes.
I am violating the order. Is there a consent to it?
Very well.
Is there any?
I will record that.
Yes.
Yes.
I am saying I am not violating. Had I been violated?
No, you said violating the order.
The other way.
Yes.
And it been violated for the 39 is obvious. But
So therefore, Mr. Basu, whatever be the case, I will have to consider these aspects.
yeah, place this judgment. There are
Yes.
what the advocates, what the court concurrently held, and my lord is still up to the mark, not in the opinion that order is perverse.
Show me.
Then I am not going to paragraph
27.
45 Consular.
27.
Now can you come to 27? If ultimately the file was appellate it can be compensated in damages. What is the difference will be directly from the construction part. There is a construction on there. On the other hand, in our view, if at this stage an order of injunction is granted against the respondent defendant from proceeding with further construction, they are proceeding with the petrol pump. It will be undoubtedly restored the construction already.
Yes. Got it.
Respondent defendant not allowed to make the construction property. That apart, if you know what discussion made about, if that amount paid to the respondent defendant having paid, I have out of pocket of 1 crore and all. In favor of the applicant, there is no reason to pass an order of injunction. Or face substantial injury for parties to the respondent with the construction property. And can come 33. Furthermore, respondent requires as directed by the trial court that particulars of the prospective buyer, they are going to construction was there, you have to come down. Here, how is it the petrol pump is run? They will notify you this. If ultimately suit decreed, they will be compensated for any substantial loss of sale. I have not realized today, but it is not in function of time, that the driver cannot buy a suit. Off-courted judgment, my lord, Mithilesh Gaur. I'm not going to that question. I am.
That argument was not there.
Not necessary.
So-
I am trying to explain and plain only. Kindly see what the plain case made out. Plain case made out that highway circular and court trust is
You see,
not.
so far as you are concerned, Mr. Vasu, I would understand the security part. Why? Because you had disclosed before the court, this is your construction work and what has been stalled. Insofar as Mr. Mal's client is concerned, he was aware of the order of injunction. He said, it does not bother me and I will continue with the order, permit me. Correct. Naturally. So therefore, he proceeded despite the order of injunction being passed against you because there was no injunction. Naturally, so he proceeded, but knowing fully well that there is an order of injunction against you.
I am only on plain. My lord, I they are plain for any cause of action. These are his right to put injunct me. Kindly, I hope my lord produce the plain. It's not my right.
Okay, show me where, show me why to whichever paragraph you want to show me. But in the process, do not have the entire application heard out.
In some matters, my lord.
No, but still then, Mr. Vasu.
Affriding me by showing the volume of the petition, my lord.
Yes. You are trying to.
Kindly come to 115, it starts.
Yes.
Volume 1.
Yes.
First ground, paragraph 5. What is the ground? Port trust land. I am the lessee. A third party is saying ACS is violating the port trust agreement. The first ground.
Second.
Paragraph 5. Then kindly come to GW, 5, 6, same. Now kindly come to 6. Their case is, his petrol pump is 100 meters away from my petrol pump.
That is 9. No right to.
Right. Now, what is the guideline? Guideline is before the court. See, our specific case, the petrol pump is not on highway. So how this guideline can apply? I am asking the question to myself. Court has held that. This is the guideline of central government and court has concurrently held that this guideline is not applicable to a petrol pump.
Where is that finding by the learned judge? Yes, show me.
Appellate court, absolutely clear finds.
There, show me. This brochure has not been complied with. The brochure.
But kindly don't bring brochure. Brochure is not the plain case. Plain case is the guideline of the highway. Kindly come to.
So far as the terms of the deed, lease of deed is concerned, I understand that finding is a finding of fact returned as of today.
Which one?
This paragraph 5 as of today. Paragraph 5, that statements made in the plain case.
Paragraph 5 vis-a-vis the court trust. How he can say anything?
That whatever is there.
I am violating a clause. I am subject to eviction. Now, my lord, kindly come to yes.
I see. Paragraph 12, eternal page 12.
Page 11. Kindly
No,
come to page 11.
12. It is
So,
noted.
11, everything has been quoted here. 2.2 guideline framed by the Ministry of Road Transport and Highways. However, even then, Malad, kindly come to the page 11 bottom. Even
Not 11, 12, sir. Page 12 bottom.
I didn't go to the spelling 11. Kindly turn over. See the last line. What the guideline even says. However, these restrictions shall not apply in cases egress or all such fuel stations are provided through common service road. Here we assume common service road 7 meter. Even if it is applied, not done ready. It is not offending. I say it is not applying because it is outside. It is not highway.
You did not place paragraph 12 in and 13 top. But I find from the local inspection report that the common road and the plaintiff's existing petrol pump and the proposed petrol pump of the defendant, number 1 is a carriage road.
Carriage road.
Not service road.
And this is service road, not even highway. Highway is, my lord, it is said how much it is, probably 2 kilometers away from here. 4 kilometers. Kindly come to
State highway is
page
5
13, first paragraph. My lord, paragraph 13, page 13. Can you see the first paragraph?
I've seen it.
This report is not subject matter of challenge. Court has perused the report.
Now comes the only brochure point.
No, sir, it's not the plate. Can come to the plate. Absolutely, sir. Court has directed to take this point. To taking the point, my lord, plain required to be amended. Without amending, my lord, the point can be taken. Well, kindly come to 115 once again. I tried in vain to find out any sentence regarding, my lord, that so-called procedure. Only 300 meters because of the highways restriction. Paragraph 9 say, see same thing. This distance of guideline of highway. And
The,
there-
why did you fight? No, this is, what is this writ petition? WPA 4753?
all courts.
No, no, it is your, whose petition? Yourself. You filed writ petition.
Justice Sampa Sarkar. Justice Sampa Sarkar.
4753, page 706.
Okay.
For the petitioner, Niladri.
That is
Maybe-
separate matter.
That's it. So,
Forward
I
to
will.
the my lord, I tell that.
I see, I see, I see.
Now it is my lord, judgment.
No, no, I thought, why is this order here? So,
And my lord has seen my name, so I have appeared in this matter.
I thought that's the reason I thought that you are. Yes, anything else?
Anything required, my lord, after the court concurrently held, can you rely on CS judgment? Why unnecessarily I will be stalled today? Any private case? Balance of convenience is also in my favor. Let me continue. If ultimately Suk succeed, it will be stopped then and there. And apart from that, my lord, rival businessman is emphatically saying I am the rival businessman running 100 meters away from you. Because that clearly says you cannot challenge me.
Yes, Mr. Amal.
Nothing much, my lord, only lordship was referring to the injunction, whether.
You want to still say that you had completed everything because your completion does not help you.
So far as my part and so far as my expenses, that is steering. Kindly comes to the.
So you are happy if your expenses are secured. Then
we have to run it. Otherwise, we'll not get back the money.
We are business, we are running.
We have put,
Business is-
we have invested by giving the first stock. And we have done the.
the brochure has been published by you.
Yes, it's a joint OMC. All three oil companies.
Let's come to the brochure once.
I will request your lordship not to go to the business. Because this is not the subject matter. Plant has not been amended.
Because it was before the code below, not something new document is being shown.
But your lordship is.
Let me see that.
Whether target judge was correct. If it is correct, the consequence can run it down.
Very
He's
well.
amending a plane. He is looking something.
Very well. Let us find out.
Oh, for the lord.
Let's find. Yes, Mr.
Only page 467. Page 467. The order of Justice Vasu. Kindly comes to page 470.
No, the brochure, come to the brochure once. For me, it's part of the
514.
514. 240. I'll come to you. Let him respond. Yes, sir. Yes, sir. Yes. And kindly come to, yes, yes, this is a public document. This kindly come to 47, this part.
Excuse me, what she is referring to?
247. This ownership part which they say. That you did not inquire into this issue at all.
Yes. Everything, if it is wrongly done, my lord, they are liable for eviction by the court trust. It's an absolutely inter-party document. My lord, X has a contract with Y. Can M or A go and invoke that if there is any violation of the contract? That's very, my lord, with greatest of respect, my lord, very elementary.
Third party will come.
My lord, third party will invoke a lease, a covenant in a lease agreement. And that in a civil suit. I could have understood appeal has been filed.
So appeal, in case it
do
is
not know.
appeal,
I
in
do
case
not
of
know,
appeal, being a Navaratna company, you are saying that you will be your Navaratna company. Then in that case, you will be saying that they will be having a legal right to enforce a claim
They
against
do
you.
not have. They are interested party. They cannot. They cannot. Because of their pleading that they are within 200 meters from my pump, their business will suffer. But kindly see, all this has been considered by the other revisional.
Why was this provided at the first place in your brochure? Why was this there? Why is it there that this petrol pump should not be set up within 200 meters?
That is directory and recommendation. It's never a mandatory cause. Let them demonstrate that this.
Why would we be going through practice normally? You will find this side, that side by side.
That's a highway. It's not mandatory in West Bengal. IRC is a recommendation. It has no statutory force. And that has been held in many high courts up to Supreme Court. Kindly sees the order passed by Justice Basu so far as our part of completing it.
Justice Basu permitted you to complete. If it's your own peril,
it shall
your own peril, sir.
not my
Obviously.
peril. It said they have not asked for any injunction against me.
Correct.
Therefore, it shall not deter me from completing.
Justice Basu said you go and complete. You are saying, sir, no.
Shall.
It was for you to go and complete, sir.
Therefore, the order of injunction shall not deter the
Correct.
to continue with the infrastructure.
Correct. So it is at your peril you have done so.
After this order, shall we stop?
Oh, no. Why will you? It is, you have taken a conscious decision to proceed. So therefore, your decision to proceed was not interfered with by the court. That does not give you any premium for that. That is on a different footing. But Mr. Basu's agreement is on a different footing.
January construction started, my lord, and they came up in June. First court, they failed to obtain an injunction. On the appellate court, they obtained an injunction. By this time, everything was over. Kindly see when they approach the court. Kindly see the balance of convenience.
It will take another, how much time will take?
But I have nothing else to add. I have nothing else to
No,
add.
I'm saying it's 115 now.
2008 11 SCC page 1.
Then I'll come at 2 and come back. Finish it up. Finish it up. Yes. Yes.
And another maiden appearance is behind me. Another maiden appearance before mine.
Salasan matter, you know, Mr. Anirban Rai. Yesterday he said he has some difficulty. Therefore, I fix it after the recombent. No, now you want, but I'll take it up after the recess, after I complete this matter. Your matter, which is the matter? Yes, Mr. Dotto, this court did not pass the order. You have to apply before the other court. I don't have determination any further in that matter. No, it is unfortunate. Cannot, because the original order is by Justice Pal. Please understand, I had determination of Justice Pal because taking up the matter for that particular period, Mr. Datta came and mentioned, I asked him, order passed by this court? He said, yes, order passed by this court. I did not pass the original order, sir. Then, now I don't have, another honorable judge has. You ought to have said so. Yes. That does not change it to my order, Mr. Datta. Don't tell me all this. Yes, yes. That's your order. That's it. Yes. And this means the court which we having did. What are you saying? You ought to have mentioned this properly in the morning, sir. Yes, Mr.
Madam.
Will come
No, the
after this matter is over.
other side is here.
After the matter is over. I'll have to wait. This matter is continuing.
Yeah.
The other matter is.
So we'll come back at after.
Original side matters. Wait, I'll be taking.
All three parties, my matter are present. The OL, my other side, just 9th December, your lordship can fix
It will be there. It will be there in the list. It will be there in the list.
Lordship going away, coming back.
It will be there in the list on 9th.
So after the continuing matter,
I'm not passing any order in your matters today. It will be there in the list. Come on the date when I come back from the circuit.
At this 1 p.m. after the continuing
Yes,
matter.
after Mr. Mitro's matter. Mr. Mali, you have concluded? You want to add anything? Yes, yes. Yes, yes.
14.
Sir, I did not stop you. I wanted to, because it was 150.
Madam will never does that, madam.
I was saying that if you want to make submission so that I can come back.
Madam, that's I will draw your lordship attention. Dates, my lord, are very important for passing of an injunction, which was not there before the first court, for the first time issued by the first appellate court, modified to some extent by the revisional court, and then furthermore, it was not there. It was only issued only on 12th June. That was for the first time an interim order was issued for a limited period, which was to some extent modified by the revisional court. So, my lord, at that backdrop, my lord, certain dates will be very important. My lord, 18th July.
Final hearing I am not doing today.
No, my
In
lord,
any
my
event,
lord, even for the purpose of passing.
I would have done final hearing in this matter after what Mr. Basu submitted, but no, it's not possible because even if I want to, it's not possible. That entire matter, a final hearing, then I have to. There is a difficulty, Mr. Basu, that if I do have to do the final hearing, then I have to hear Mr. Mitra once again on this. So I am not on final hearing, Mr.
I am only.
I've heard yet.
The grant of injunction. Whether, my lord, in terms of the ECS judgment, whether it deserves an injunction to be passed today.
Yes, you have submitted.
That is the factor to be considered by.
Because today, if you argue that, all your contention have to consider and respond, Mr. Mal, in that case, so that will be not.
Having my
Yeah.
is there.
No, not here. It's here. I have to complete all this. I have to complete all this. Yes.
Not my contention should be given.
Absolutely.
But I am submitting. Your lordship today is completely considering whether.
Absolutely. To grant or not to grant the protection, only to that extent.
Injunction. If the injunction is not granted, what is the irreparable injury?
That you have indicated
This is
by that judge.
not the entire matter. This is our contention. Plaintiff is not amended, so this point is not German.
Mr. Mal, so far as on the brochure, you want to make on the brochure any other point, just only that, because I'll seek for their response.
Sure. The only point.
That is the only point available.
Subject to what Mr. Basu has
Should
said,
not
I
be
am
looked into.
that.
Should
But
not
I
be
want
looked
to
into, he said.
If at all they want to rely, what they are lifting at, my lord, at the cost of repetition is that lease agreement, court trust, and the deed.
That's it. Yes, madam.
My lord, just one good fact. My lord, initial load was given to the dealer on 31st May 2024, much prior to the filing of the suit. Because for testing purpose, the entire.
I'm not going to that extent today. I'll be going on the admitted position.
Consider the
Entire facts aspect, I will consider if I grant the interim order in their favor, then this I'll consider subsequently. If I do not grant the interim order also, then also I'll consider this subsequently. Because while consideration of the final hearing, this factor of grant or non-grant will be absolutely irrelevant. Will be absolutely irrelevant. Yes.
only.
And that is what all along you had been pressing throughout, that these are all prima facie.
Even my lord, before filing of suit also, the load means the.
That is all right, sir. That we are in a shorter campus. Yes, madam. Yes. Very well. Assuming the brochure is fine, assuming whatever you are saying is correct, you are only, Mr. Mitro has only brought attention of the court to page 47 to 47. And what according to you is the infringement of the brochure? $247. Any other point? I accept. I know. I accept. Assume accepting. Then what is the breach? What is the breach? Yes, 250. Very well, 250. Very good. 250. Come to 250. That is, they have to bring by an additional evidence. That document, when did you get that document? Yeah, was that document brought to the notice of the trial? Naturally, sir.
He is asking, he has relied the document without reading, but how far is journal?
See, I just asked them. I asked them whether it is there or not. They say yes. Then have to show me, sir. Please, sir. You are not in the app. You never interject anyone.
New thing has been said.
You never interject anyone. She's
I cannot say.
especially today. You should not interject her. You remember why? Yes. Let her make a submission. Yes, sir. Come back to the writ petition order once again. Paragraph of the fair, you have written note, 51 paragraphs. Oh. Yes, yes. And what did the learned judge say on this? Nothing. Nothing. And you had pleaded, you had made this submission. No. No, these are page numbers, internal page 6. Firstly, secondly, thirdly. These are the 3 points you argued. Thirdly, it is contented. Is that the point? And where is any response to this? Nothing. According to you, there is nothing. Their contention. What is the judgment? What is this judgment? 2012? So they cannot rely on here. No. What is this judgment? Hand over that judgment. Given the number one violates condition, learned advocate for the plaintiff has relied on decision. Such a this is not the one, my madam. Jairaj, you did not rely. Very well. And any answer to this by the learned judge? No, any answer. I'm complicated. Where, which page? Which page? Very well. None for I think this is enough for now, because either you get it or you don't get it. Any response or that part is okay. Any response to that submission? They raise point that irreparable loss. Today, both courts have said, whatever you suffer, any judge relied on the judgment by Justice Chatterjee. So it is that judgment. You have a copy দুটো দিয়েছে একটা এটাকে ফেরত দিয়ে দাও তো এটা আমাকে দুটো দিয়ে দিয়েছে ওকে দিয়ে দাও ম্যাডামকে দাও ম্যাডাম so that they had handed over this copy. Mr. Vasu, anything?
Very preliminary question. I repeat.
Please don't. You are, sir, such a senior person. Don't repeat, sir. You said so. She did not answer the judgment. You did not answer the judgment, madam. You want to still answer? Just go through this. Kindly answer the judgment. Kindly give us the judgment that she has to answer. You have rest. You have all said.
One justice Banerjee. Justice Banerjee. One judgment.
Now it's in reply. I know further judgments. Madam,
You want some?
wait, say, man, let madam give the answer. I'm on this. You give a yes. You relied on the Justice Strategy judgment, EC Industries Limited, SP Real Estate Developers Private Limited. She wants a copy. No, give her a copy, otherwise she's very healing handicap, whatever she wants. You rely on this and then give it hand over to her. They had relied on paragraph 21 of this judgment. Paragraph 14, then 21 of this judgment. I marked it. It was coming up from an interim or from final order or interim order passed by the High Court. Final disposal, not interim.
Doesn't matter, ratio.
Yes.
Findings are concurrent.
Absolutely. Pat on the point judgment so far as Advocate Commissioner is concerned. Advocate Commissioner is concerned, very difficult for this court to take a contrary view. Whatever is there, on facts.
No
And no scope for that.
objection to the report of the.
Correct, Mr. Basu. No. Let us see, madam, what happens. Let us see. No judgment, no. And no points, Mr. Mal.
Running the paper from the same place. It is
These are-
violating IRC. He can run, I cannot run. There is a statutory violation.
You are running, it is the company owned, dealer operated, or dealer company owned, company operated.
It is dealer owned because
Dealer operator. Both are dealer operator.
dealer operated.
It's company owned, dealer operated. It's company owned actually,
It's not company.
not company owned.
No, because it was a lease.
Same.
Clause is either the dealer has to own it or take it on a long term.
Dealer owned, dealer operated.
Both are same, identical.
No, I'm just asking. Dealer. Yes, yours is company owned, dealer operated. Previous those were several matters were there on this. That's why I'm asking you.
Company operated.
Yes, that's why I'm asking. Coca-Cola, yes. I accept your contention. It's come for so far. This is neither here nor there. Why are you troubling yourself on this?
Who said I have not obtained?
Your case is neither here nor there. Issue. Yes, you have all done what you wanted to do. It is now for the court. Yes. Madam, you undertook to file the the certified copy. Both the certified. Second certified copy you have got? No. Which one you have got? No, the previous one you undertake. At the very outset. no injunction. Today, if I pass an order of no injunction, if the injunction was continued, I would have passed the status quo.
19th September.
Yes.
19th September.
I'll hear you on this. No, because there was no injunction in your favor. Why did you not? It's for you. Why will I say? It's entirely for you. Why you have not preferred? At that stage, why did you not? When you did not get, immediately you did not come. 4th November, this court, you could have moved this court on 4th of November. You did not move the court on 4th of November. Hey, which page is that order refusal of interim order? Ex parte ad interim.
Refusal interim order by the trial court.
Yes.
19th September.
Yeah, so it was not granted on the first date. So where is that order? Any order? Madam, can you download it and mail it to my officer? No, you mail, Mr. Chattopadhyay. Mail it to my officer.
Yes.
Mail it.
Yes, I will.
And then,
By today, my
call the next matter.
Yes. It's for the patient and long hearing.
Yeah, this the certified copy. Let me open it. Certified copy of the order filed in court today. Leave is granted to the petitioner's advocate to append the original certified copy to the petition. You append it to the petition. Or ask your advocate. Yes.
Watch petition. 252.
Hearing madam.
Yes, she's the caveator's at. She's the. Sorry.
Mr. Member, sir.
No.
Mr. Bose, you should no longer do this. You should understand now.
No, I was about to speak on her behalf.
Tell me what.
No, she has told me that she's the advocate on record. She's lodged caveat, but she's been led by Mr. Somnath Bose. He's in some personal difficulty. He's not in court. I'll tell you.
The list on Monday. I'll place it in the list on Monday so that you can move. The other men have done so that you can move this because
Move where, my lord?
the other court as an
No,
urgent
that is only urgent matter.
It's an urgent
No,
matter.
I'll tell you, lordship.
That they are taking an adjournment.
No, I'll
Place it for hearing.
I'll
as
tell
an
you,
urgent
lordship, the
matter.
difficulty. There's a continuation of an order of injunction. Upon payment, I'll tell you, lordship gives me 2 minutes by the clock.
Yes.
2 minutes by the clock.
Sir.
I'll just take 2 minutes. My lord, 1958.
Why 2 minutes?
I'll tell you. There's a tenancy given by the Kolkata Port Trust in the year 1958.
Difficulty is, see, they are in difficulty. They are saying now.
No, but my lord,
By
kindly appreciate one thing. No, I'll tell you, lordship. No.
You are appearing for trust.
For Port Trust, my lord.
No, but the difficulty, I'll tell you, I cannot be dispossessed because somebody is in difficulty. That's the problem. So then let them give the undertaking that I will not be dispossessed in the 2 days.
2 days.
I'm okay. I'm fine with that.
But
Yes.
keep the matter on Monday.
Yes.
Come and argue. Will not
Yes,
take a
yes,
step.
ma'am. Yes.
I'll kindly decode that. I'll
Just
come
like
back
a
on mine.
situation. What is this, Mr. Bose?
Kindly, because we not kindly appreciate. Dispossession is something.
Which order?
Well, the order of the
Calendar
district.
process.
Yes,
Calendar-
the impugned order. And there was a continuing order of stay.
It's taken up. There shall be such payment must be made within a period of 2 weeks from date. Madam, I'm placing this matter after 2 weeks.
Oh, very well, my lord.
I'll grant you. এইটা কেন ওই যে দিয়েছো না ডেটটা একেবারে দিয়ে দাও 10 তারিখ 10th madam I'm placing and it's easier for you 10th junior will be here or else then I can place it next week in the list then you fight it out.
Possible on the
9th is the first date. Okay, monthly list of December 2024 under the heading returnable motion marked 9th. Marked 9th of December 2024. There shall be an unconditional interim order restraining the respondents from proceeding with the order dated such and such. Till for a period of 2 weeks from date. In the event the petitioner complies with the above direction, the interim order shall automatically stand extended and shall continue for a period up to the end of December 2024 or until further order. End of December. Your junior. Now you have to have juniors, sir. No. It is high time, sir. Yes. No. Extension will be granted. If you comply with this order, extension will be. If you do not comply with the order, then certainly situation will be different. Put in 5 lakhs. Also, last month they paid, madam. Last month.
We've been paying all through.
And sure, very well. So 2 months, if you do not, 5 lakhs if you pay this month, so that will cover.
Yes. It'll cover for 10 months.
No. Maybe there would be a shortfall also.
Then your lordship keeps it in the other way.
Chalo.
Grateful.
আর কিচ্ছু নেবো না হয়ে গেছে
Lordship would not be taking up the original side matters.
I called it already. You are not there at once.
My lord, I was always there. My lord, I was waiting for my turn.
That's the one.
This had to be, my lord, lordship is not there for 2 weeks. Kindly, this is an ALP which has to be heard. Kindly fixes this any day after your lordship is back. This can be heard and disposed of. This is the only prayer. Yes, my lord, this is an application under, my lord, clause, this is for clause 13 of the latest patent for transfer of a proceeding, my lord, to this honorable court from the Alipur court. My lord, lordship had possibly had the occasion to hear this before. Now this has to be, my lord, heard now. There are, my lord, execution proceedings, and my lord's voice is not audible, clearly not.
This in the month of December. I think that will be better because today, from tomorrow, I'll be not be taking up for 2 weeks. So mention.
Yes, lordship, as and when lordship is coming back and the business of the court permits, lordship may fix it up.
Only 2 weeks, practically.
My lord,
Effective.
it's a clause 13 application, not more than, my lord, 15 minutes either side.
You see, appellate side matters will be there. So many matters are there. I'll
My
be
lord,
taking your side matters, but no hearing matters may be possible.
my lord, I'll take my chance. I have been waiting for a while. My lord, what is happening? I'm telling your lordship, my lord. This is an execution proceeding which is getting delayed. And when I file an application for expeditious disposal, I get a date in October 25. My lord, it's unheard of what's happening, my lord, in the lower court. My lord, I need to draw some facts to your lordship's notice.
This is item 1.
He's mentioning item 1.
Yes, item 1. Item 1.
My lord.
Very well. Very well. I'm not
already in the list.
Oh, it's there in the list. Very well. Yes.
I am opposing this application.
Yes.
But his grievance, my lord, as your lordship has heard him also.
I'll hear it after when I come
may
back.
not be
today.
necessary because his
Hey,
grievances.
let this matter be written in the list.
My lord, there's just one prayer. My lord, in the last order, directions for issuance of rule was to respondent number 2 and 3 was there, but there was a change in advocate on record. So there were some requisites that were not submitted before the department, and hence the rule could not be issued to 2 and 3. My lord, may kindly renew the direction to issue rule upon 2 and 3 to show us as to why.
I have to check up when I come back.
My lord, the order says that. My lord, the order says just, my lord, the prayer for renewal or the rule issue on 2 and 3, my lord. That's it, my lord. Respondent number 1 had accepted the rule on the first day, my lord. They had sought for time to file affidavit in opposition. Just the, my lord, rule could be issued.
13th of October 23 is the order my learned junior is referring to.
Yes, what do you want here?
My lord, the rule on respondent number 2 and 3 could not be issued because there was a change in advocate on record. There were some requisites that the the advocate on records had to
type provided in this.
My lord, they are saying the the department is saying the direction has expired. You need a fresh order for us to issue the rule on 2 and 3, my lord.
5th January. Why direction has expired?
My lord, we had constantly following up the.
No, why direction has expired? এটা তো জেনো তো ওদের কাছ থেকে কেন অসুবিধা কি আছে?
My lord, possibly because of the returnable date indicated in the order.
January. Returnable date January.
5th of January 24, my lord, 24.
My lord, we are in November 24.
January 2024.
Yes, my lord.
Yes, that is the reason why the department is possibly, my lord.
Madam.
That all this may not be necessary. Their grievances that the matter is not being taken up before the learned trial court. They file an application.
I do not know the situation. File an application. No, this is not. After 1 year you come. No.
Yeah, file an application.
My lord, we had mentioned umpteen number of times because of the change.
I did not mention before me, madam.
No,
I would have remembered.
Not my lord, not before my lord. My lord, there was a change in determination as well. That is why we were handicapped. Otherwise, my lord, we have been very vigilant in mentioning the matter and trying to get the rule issued. But my lord, at the end, the department.
After 1 year, you have to wait 1 year for this. No, don't tell me.
My lord, may I pray for this, my lord? Since lordship won't be there for 2 weeks, we can, my lord, have this, my lord, rule, my lord, served on the contesting respondents in the meantime. This will not, my lord, prejudice any party, my lord. We will just expedite the hearing.
Let them explain this situation.
But all this may be academic because they filed an application for expeditious disposal.
আগের মামলাটা এই অর্ডারটা রয়েছে জাজমেন্টটা ঢুকিয়ে দিতে হবে।
They have filed an application for expeditious disposal recently before the learned trial court, and that has been allowed. Their grievance was that the matter is not being heard.
My lord, the expeditious disposal application has been disposed of by giving a date after 1 year. That is 6th October of 2025.
The date, there's a typographical error in the date, but my learned friend, I'm sure, has checked, my lord, the status. The status shows that the date is much earlier.
Mr. Dotto, you are leading her.
I am leading her, yes, my lord.
Why is you are submitting, madam?
My lord, because I am not being able to communicate with my senior. That is the only reason.
Don't.
My lord, I was only praying for this. If lordship kindly permits us, my lord, to serve the rule on the other 2 respondents. Because lordship will not be here for 2 weeks, I was only trying to, my lord, expedite things so that as and when your lordship takes it up finally.
Wake up and say this.
My lord, this matter had been, my lord, mentioned before other benches. We tried our luck, my lord, but the business of the court did not permit it to be taken up, my lord. And kindly visualize, my lord, the parties
none of the parties will actually suffer any prejudice. I am only serving them notice of the proceeding. As and when your lordship would take up, there would be all the contesting respondents.
Interest in the matter is that, you see, when you do not take steps in this matter for a year, then whether you are at all interested.
My lord,
That
it is not. It is, my lord, it is not like that, my lord. We have actually taken steps, my lord.
there appears to be no privacy, no urgency. Anyway, I'll come back and see.
Grateful.
My lord, kindly fixes it, my lord. In that case, as and when your lordship, my lord, has the
মামলাটা থাকবে, লিস্টে থাকবে. It will be there in the list.
December.
Very well,
The list of December. Thanks.
Anything else you want to add?
Mr. Medora doesn't want this to be, my lord, brought to this court. He knows the execution would be.
At the top, you also did not take any steps for a year.
My lord, we did. My lordship understands when lordship was this side of the, my lord.
I missed.
Lordship had enough experience. How, my lord?
5th of January 2025. I said, what is the difficulty? You
My lord,
indicated.
sometimes, despite, my lord, us taking best of our steps, my lord, best of our efforts, my lord, clients do not get the, my lord, reliefs they want, my lord. At times, my lord, it happens, my lord. Kindly.
Always you will be explaining the situation, how to come out of it, and the court will ultimately accept it. But wait, let
So
us.
if the court ultimately accepts this, I was only trying to expedite
Whether your
that.
explanation is proper or not, let us see, find out.
Very well. I understand where your lordship is coming from. I'll, my lord, do that, my lord.
You only grateful.